All right, I'm going to call the docket. When you hear your name, please stand and let me know you are here. If I do not hear you, that means that you're not here and a warrant may be issued for your arrest. To those attorneys who have clients who are in custody, their name will not be called. Eleanor Arzola. Eleanor Arzola. All right, deputies, when she comes in the courtroom, could you sit her in the box, please? Stephanie Gomez. Stephanie Gomez. In the box, please. Justin Somerset. Justin Somerset. In the box, please. Alvin Kirby. Alvin Kirby. In the box. Christopher Rodriguez.
Present.
Thank you. Erica Morales. Erica Morales. In the box, please. Daniel Montalvo.
Present.
Thank you. D'Angelo Robinson.
He's present with counsel, Your Honor.
Thank you. John Carlo Armstrong. James Lawrence. James Lawrence in the box, please. Burton Schooler.
Present.
Thank you. Omar Madison.
He's present.
Thank you. Angel Brasinho.
Present, Your Honor.
Ethan Byers. Sean White. In the box, please, Stephanie. Nicholas Canton.
Judge, we got a Zoom link for him.
Okay.
He's been accepted into the PTE program. We submitted our contract and he lives out of town. So he should be on Zoom.
Yes, he is. Just give me a moment with him. And I'll give you a reset.
Thank you.
Anna Ramirez. Anna Ramirez in the box, please. Stephen Rhodes. Mr. Canton, are you driving? Your client is driving on Zoom.
Sorry, Judge.
You need to speak to him.
I will.
Stephen Rhodes. Stephen Rhodes in the box, please. Andres Cardenas in the box, please. Ruth Ann Espinoza in the box. Victor Fernandez. Victor Fernandez. I'm understanding he's to appear by Zoom, but he's not there. Luis Marino. Luis Marino. Luis Marino. All right, and whoever is in the back with the shades on, you need to take those off. You're in the courtroom. Person in the blue shirt. Christopher Rodriguez.
Present.
Thank you. Your name is on the docket twice. Alejandro Rocha. Thank you. Juan Javier Cuellar. Juan Javier Cuellar in the box, please. Thomas Manning in the box, please. Lori Wilmer. I believe they're downstairs entering a plea. So I'll recall that at 10:30. All right, is there anyone who's here whose name was not called? All right, everyone, please confirm.
All jail cases, yes.
Jail cases will not be called. but if you check with the deputy, we'll bring your person up. Nick Catton,
Yes, Your Honor.
why were you driving?
I'm currently at work. I was trying to get to a safe spot to park real quick, ma'am.
No, you're not to drive in Zoom. Do you understand? Where are you?
I'm up in Dallas right now, ma'am, working, but I pulled over on the side of the road, not driving
Let me
anymore.
just tell you this. Next time, if you're driving while you're on Zoom, what's going to end up happening is, I don't care if you're in Dallas, I don't care if you're in Louisiana, I don't care if you're in Washington, D.C., you will be required to appear in person in court. Do you understand?
Yes, Your Honor.
All right, could I have a clerk in the courtroom, please? Just one moment. Brenna, could you do me a favor? Could you go in the back and ask the clerks why there's not a clerk out here?
Should I approach Judge?
Just a moment.
You might need to get, is it on today's app? You might need to take it back and see if you can get the file or whatever, so she has a copy of something to look at. Okay. Yeah.
And to attorneys, before you approach the bench, make sure you have your file. You can get the file from the clerk. So when the clerk comes, you can get a file from the clerk and then you can approach, but do not pass that line. I need the file on Captain. All right, we're going to come back on your case on June 13th.
Okay, June 13th.
Yes,
Thank you, Judge.
you're welcome. And your client can appear by Zoom, but he needs to make sure he's not driving by Zoom.
Of course, Judge. Thank you.
All right, thank you. You and your client are excused.
Thank you.
Adam Cox,
Morning, Judge.
good morning.
How are you?
Oh, I'm doing great. How are you doing this morning?
It's a beautiful Monday morning.
Yeah, okay, you need to speak up. For some reason, I can't hear you.
Okay, let me try and talk up a little bit more. Is that better?
Yes, I can hear you now.
Okay.
So who's your client, Mr. Cox?
Judge, it's Jamarian Smith. The court had kind of set him for today. You excused his appearance, although he is in custody. He has a family violence case that I think is unfiled, but in the system, so to speak.
All right, so the person that you'll need to speak to is Michael Villarreal. Mr. Villarreal, if you could approach, please. All right, Mr. Cobb's client, Jamarian Smith. He's saying that there is a case that is sealed.
Let me look at it.
All right, thank
Just
you.
give me a second.
So just give us a moment, Mr. Cobbs, they'll look at it.
And Judge, I was just going to suggest I can come over to the courthouse if that's okay.
Yes, if you could come down to the courthouse, because we're actually in person today.
Okay. All right. I did not know that. I did receive the Zoom link, hence I was thinking it was on Zoom. But I'll let me log off and I'll walk over shortly.
All right, thank you.
So it doesn't show the actual. Yeah. It doesn't show Judge Peppers.
Do you have a file? All the attorneys in court, if you want to approach, what you need to do is you need to get the file from the clerk so that the clerk can give me the file, and do not go past that line.
Yeah. You know, I don't think it's a whole bunch of records, but I'll get it to you.
Yeah. Talk to.
I think so. I think we're gonna look at one thing. We were thinking it was a caddy. No, I don't like that. So I'm just gonna take it.
All right, did anyone walk in late? And by late, I mean after 9 a.m.
Yes, ma'am.
Who is that?
Eleanor Bono.
You need to take a seat in the jury box. Who else was here late?
Speaking like this, Sean White, my client, Judge.
Take a seat in the box.
Okay.
My
Yes.
client was probably late as well, Anna Ramirez.
Seat in the box.
Without counsel.
Yeah.
No, that's fine.
I'm not saying yes, yeah, but see if we get this like some days credit.
How about that?
Yeah. Yes.
Just for record.
That's why kind of.
And the orders are.
You know, it's. You know.
Once it goes in motion.
Right, thank you. All right, Mr. Charles, on the motion for bond conditions, did you speak, confer with the state?
I just did this morning.
Is there an agreement?
No, they're not in agreement.
All right, is your client here?
He's present.
All right, state, are you ready to proceed on this motion?
I can't, Judge. I don't think, I think I'm just going to argue just the cases he has filed. I don't need to give you anything other than that.
All right, Brenda, are you ready?
I'm ready.
All right, the court is calling 2021 CR 9973B, 2021 CR 9974B, and 2021 CR 9975, State of Texas versus D'Angelo Robinson. Can I have parties announced for the record for the state,
Ryan Groomer for the state of Texas.
for the defense?
Albert Chidas from Mr. Robinson.
Is your client in custody?
He's present, Your Honor.
All right, Mr. Robinson, you need to come forward. If you wanted to separate them. you could. All right, and to attorneys, it would probably be helpful to the deputies if you don't block their line of sight to the jury box.
We're just trying to move out of the way.
I understand. All right, the court is in receipt for motions to modify bond conditions. State, have you had a chance to review those documents?
I have, Judge.
And State, are you ready to proceed?
Yes, Judge.
All right, defense, it's your motion. You may begin.
Yes, Your Honor. I'd like to just briefly call my client, Mr. Robinson.
All right, Mr. Robinson, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Okay, you need to speak up.
Yes, ma'am.
All right, is there a reason you can't talk louder than that?
Yes, no, ma'am. Sorry, I apologize.
No, I mean, you need to speak up so the court reporter can hear you. I know when people are talking to their friends outside, they don't whisper. So you're gonna have to make sure you speak up, otherwise the court reporter can't hear you. And if the court reporter can't hear you, I know I can't. You understand?
Yes, ma'am.
All right, you can lower your hand, defense.
Thank you, Your Honor. Sir, could you please state your name for the record? And Mr. Robinson, how old are you right now?
18.
And
All right, stop. Let's do this. Switch him with the state so that Brenda can perhaps have him closer to here.
Oh, thank you, Your Honor. And are you a high school graduate? Could you speak up, please? And are you trying to get your GED?
Yes, sir.
What kind of program are you enrolling in?
It's a college program.
Okay, and are you already enrolled?
Yes, sir.
What's the requirement for you to get your GED?
I have to appear in person.
Okay. You're out on bond right now. You're on leg monitor, so you're confined to home. You understand that, right?
Yes, sir.
Have you had any violations? Have you been doing anything you're not supposed to be doing?
Yes, sir.
Any violation reports, anything like that?
Yes, sir.
And you've been reporting to pretrial services, is that right?
Yes, sir.
And who's your pretrial officer?
I had a last name of Martinez.
Okay. And did she line up a job for you?
Yes.
And what kind of work is it?
Landscaping.
And would that be doing landscaping at where, in San Antonio?
Yes, sir.
Okay. And are you asking the court permission for partial house arrest?
Yes, sir.
Is it so that you can attend and get your credit recovery?
Yes, sir.
And is it for you to be able to work?
Yes, sir.
I have no further questions here. Oh, are you going to follow the rules of the court if the judge grants this?
No, sir.
Is the judge going to have to worry about you getting arrested for some new offense?
Yes, sir.
I have no further questions, Your Honor.
State.
Nothing from the state, Your Honor.
All right, I have a question. What are the hours of this GED program?
I know it's from 9 to, I want to say 4,
Where's the location?
Palo Alto College.
What days of the week?
Now,
What days of the week?
Monday through Friday.
All right, and the employment. What hours are that?
I haven't talked to him just yet, but my pretrial officer did say that it's a for sure job because he's hired her past class.
All right, so here's the problem I see. If he's doing GED from 9 to 4 p.m. on Monday through Friday, when is he gonna do this long thing that he's supposed to do?
I attached an exhibit, Your Honor. I believe the job is from Monday through Saturday. Something like, it's on there like 9 or 8 to about 4 or 5.
Well, he won't be able to work on Monday through Friday because he's getting his GED from 9 to 4.
And I know that he wants to do both things, but he may have to talk to the credit recovery people and work something out.
All right, State, do you have an issue with Mr. Robinson obtaining his GED from 9 to 4 p.m. and it's showing that he's at Palo Alto College?
We don't have a huge issue, Judge. I think the only thing is we just wanted to make the court aware, you know, Mr. Robinson is charged with some very serious offenses. I believe he has 2 aggravated robberies that he's been charged with and indicted on, as well as an aggravated assault. Myself and his attorney have also spoken, and I think everyone's aware. He's also under an investigation for another aggravated robbery and as well as an assault choking. I guess our concern that we just want to make aware to the court is he does have a lot going on in terms of cases filed in this court. For those reasons, we just want to make sure that the court and that he's aware of the seriousness of the situation. He's charged with some very serious offenses. You know, we would ask that maybe we can establish a track record with the GED program before we go into the working.
Okay. And is Palo Alto College aware of the pending offenses?
I don't know if they're aware of the pending offenses. Obviously, the prospective employer is. I don't know about the college.
Okay, well, Mr. Robinson, I don't have any issue with you obtaining your GED. Are you living with your parents? Where are you living?
with my girlfriend.
Oh, okay. So, I have no issue with him, with the GED. With regards to the employment, we need to pin down some times more, because I don't see how he can do, the employment and complete his GED. And whatever he does, I'm not gonna want him out after nighttime.
No, and I've explained to him that he would have, X amount of time from leaving from his apartment to getting to the college, leaving the college and going to the apartment. He wouldn't have the liberty to just take a detour and, 1 hour detour.
All right, Mr. Robinson, this is what the court is going to do. The court will allow you to obtain your GED at Palo Alto College, but you're gonna have to provide a detailed schedule of those classes to pretrial services. So if there's a schedule, you need to provide it. And you need to make sure that you are where you say you're gonna be. Otherwise, we're gonna be here on a violation report. Do you understand? All right, is there anything else?
No, Your Honor.
So far, and also, Mr. Charles, if you can, the court will consider employment, but I need a detailed schedule of that employment. All right, so with regards to the cases, where are we on discovery?
I did, sorry, Your Honor.
Yes. You have to
I
pick
did
information?
file motions requesting certain things on these 3 cases, but I just did last week, so I don't expect the state to have everything. But I did request certain documents, reports, that sort of thing. Like specifically, I wanted to see some kind of a fingerprint report on one of the 2 of the 3 cases.
Judge, I think we conferred just on the bond issue right now. We can confer with him on the other issue. I did read a note that I think maybe Marcus may have made regarding something about a thumbprint, so I can check into that stuff.
All right, so I'll let you all confer and then give a new reset date, but Mr. Robinson is not excused from court yet.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Yes, just give me a moment.
Oh, I was just. We've got. That's okay.
You guys can sit down and then she'll call you up for the case. Thank you.
All right, who's here on Jacob Brown?
Your Honor, Paul Smith representing Mr. Brown. This was a real quick background case. My client was sentenced by Judge.
I'm aware of the case. So here's my question. State, are you going to have any objection to the motion for new trial?
Not necessarily, Judge. The only suggestion I may have, though, is would maybe a better motion be just a motion to reconsider the disposition, and that way the case doesn't open back up and potentially he can, you can just make a decision as to the disposition. It was a case, I'm sure as you're aware, that we agreed to continue him with him going inpatient, and that didn't happen in front of Angelina.
All right, if you would like to follow it as a motion to reconsider.
Well, yes, Your Honor, that would be, I was worried about it because motion to reconsider / new trial, I think that.
Yeah, we can just call it motion for a new trial or reconsider and ask Ms. Ferguson the bench warrant to find back.
Okay.
Ask her how long would that take? What is the time frame on this?
We're now, the sentencing date was April 20th, so we're up to 75 days after that date.
We're a little less than 30 days right now. It's May 16th, so.
All right, so see if Ms. Ferguson can get him bench warrant quickly. If not, we can do it by Zoom.
Thank you, Your Honor.
Thank you.
Appreciate it.
Here's this.
Thank you so much. Judge.
You're welcome. Just make sure that's done properly. All right, who are the parties on Sean White? All right, Sean
Mr.
White,
White is in the box.
Mr. White, if you'll come forward. Why were you late for court?
I was here, I just used the restroom, but I mean, I didn't hear, but it was like 9:01. So.
I actually met him down the
Yeah,
park.
he saw me in
He
the
was
park.
actually on
No,
time.
but he was not, no, he was not on time. He was not in the court at 9 a.m. Docket starts at 9 a.m.
I apologize.
All right, do not be late for court again, okay? All right, what is happening with Mr. White?
Judge, we're going to announce we're going to take this to trial. I have an offer already, and I only have one motion for discovery. And I need
Discovery issue. What is the outstanding discovery issue?
we just need some background information on the complaint witness.
Okay. When was the offer tendered?
Today.
All right. So, Ms. Ferguson, on Sean White, I need a 2-week reset for a plea deadline date, please. All right, we'll see you back on May 31st. That will be your plea deadline date. But the judge who will be here may also have it set for trial, so it's plea deadline date and trial date.
Thank you for the warning.
Okay. All right, and make sure you fill out the reset form. Andres Cardenas,
Your Honor, I'm here on him.
We have a pending competency motion on him. He's actually at the San Antonio Behavioral Health Hospital. This is the one that was listed as a missing person. He actually turned up in Laredo. They don't know how he got there, but he's under the impression that aliens are trying to abduct him. I work for the NSA, just a whole bunch of stuff. So we have a pending competency motion.
Okay.
He was previously found incompetent on this case for an extended period. And again, he is at San Antonio Behavioral Health. Right now, the state actually initiated a guardianship proceeding over him. I don't know what's going on with that, but obviously we need to get him evaluated for purposes of this proceeding as well.
All right. And have you spoken to the state regarding this?
It's been a while. I'll confer with them though.
All right. If you'll confer with them and see where we're going with this case.
Yeah.
All right. Yes.
We conferred. We're until the competencies come back one way or the other. I don't think there's anything we can do.
All right. Could we go on mute, please?
Yeah. We'll figure it out. How are you? So how are you?
Could you let us into the hood now?
11, thank you. We'll see you then. Thank you, Mayor.
Mr. Davidson,
Yes, sir.
what is your client Juan Montemor charged with?
1 month more.
Because I have this motion from you, but it does not have the office in the motion.
Sorry, I'm drawing a blank all of a sudden. Is it a motion I filed?
Yes,
Yes. May I approach?
yes.
Look at it, please? I'm sorry, I picture him because I see him a lot. I'm sorry, I didn't know you're all right.
That's okay.
I've had a lot of indecency cases lately. I got that one mixed up. A minimal amount, so
All right, because I have to go with what they have listed on.
I understand. Just a minimal amount because there's only going to be some very specified things.
All right, even though it's not a first degree, I'll put it as a first degree.
Okay, thank you.
You're welcome. All right. Do you have your file?
Confirm.
No, I need the file. I need the court file.
I don't think there is a file yet, Judge. It's not indicted.
Oh, okay. Just give me a second. I'll take you up just as I finish with Mr. Rittenhour. Mr. Rittenhour? Good morning. So there's an issue with, I guess, investigative funding or something?
That's one of the issues, yes.
Okay, the court, you never approached the court on an increase in funding, you just filed a motion.
I filed 3 motions, Judge,
Yes.
granted 2 and denied the 3rd.
Yes, and so on the third motion, I'll need you to approach and tell me in general what it's for. I can't just continue to give.
Are you asking, saying you want to readdress
Yes,
that 3rd?
just refile it, but
Oh,
on
refile,
the,
okay.
yes, on the third, when it's done, like for the third time, first, second time, I just do it automatically, but the third time, I need to know in general what's needed.
Each one of them is a full 8 motion, Judge, but I'll refile.
All right, okay,
I'll do that, and I'll have to change the investigator because the one I had before, used by the first 2 lawyers, is no longer good. So I've already talked to somebody else.
okay.
Let's go.
All right, thank you. So if you can have that filed, are you able to get that filed this week?
Yes, Judge, I will.
All right, and we'll see you this week.
All right, thank you.
You're welcome.
May I approach?
You need to have the court file. If you're gonna approach.
Who has it?
The court file, I don't have it.
Where is it? Is it back in the clerk's office?
No, the clerks are sitting right there.
Oh.
Adam Cobbs?
Huh?
Which case do you have?
Marion Smith.
All right, so did you speak with Mr. Villarreal?
I did. It's going to indict.
I need to see if she signed
All right.
the order.
And that's the only case that's open, correct? Everything else is closed?
That's my understanding. I don't believe there's anything else that's sealed, so to speak.
Yes, Judge, and I've looked at it and looked at just a brief overview of the case, and it's not a case that we can just dismiss based on his sentence on the case just tried.
All right, well, you're still the attorney, Mr. Cobbs.
Thank you, Your Honor.
You're welcome. I'm here to help us all.
Do they have it?
By the way, I'll be back with my voucher shortly.
Yes, please bring it.
May I be excused, Judge?
Yes, you may. All right, who are the parties on Erica Morales? Erica Morales.
Yes, ma'am, Your Honor.
Yes.
Ms. Wells.
Yes. Why were you late today and stopped chewing the gum?
Ma'am, honestly, there was just a detour and I have no excuse.
All right, court starts at 9 a.m. Do not be late again for court unless there's good reason. Do you understand? Everyone is aware of the construction. I have so many construction stops on my way here. But I get here on time and I expect everyone else to be here on time. Do you understand?
Yes, ma'am.
All right, what is happening with this case, Mr. Tompkins?
We've been able to talk, Judge, and if we can get one more setting and it will be dispositive, I need to speak to the victim again on the case, and then we'll have a resolution next setting.
2 weeks.
2 weeks is perfectly fine.
All right, Ms. Ferguson, can you recall this for, I guess, May, the end of May, please? All right, we'll be back on May 31st. Make sure you get your reset form.
Thank you, Judge. May we excused?
Yes, and I will not be the judge here on that day. There will be a different judge. You need to make sure you're here at 9 a.m. Do you understand?
Yes, ma'am.
All right, we'll see you back on May 31st. May 31st, excuse me, miss.
I'm sorry, Judge, I told her.
May 31st is your pre-deadline date and also your jury trial date.
Thank you, ma'am.
You're welcome. Yes.
Judge, may I approach?
Just give me 1 moment.
I'll let her know.
All right, Mr. Charles, yes.
Yes, Your Honor. I conferred with Mr. Sanderson. They haven't had a lot of time to look through the motions. Like I said, I just filed them last week. But they're going to try and comply with my request. So I just want to let the court know.
All right, just 1 second. Can I have a file on Robinson, please? All right, Ms. Ferguson, I need a 1 month reset on Mr. Robinson, please.
Back on the 21st.
All right, we're going to see you back on June 21st.
Thank you, Your Honor.
Make sure your client gets the reset form. And work with your client on speaking louder so people can hear him.
Yeah, I think he's just shy.
But people are not shy when they're out talking to their friends.
I know. Thank you, Your Honor.
All right, you're welcome.
It's already signed. No, signed by the judge. You want me to sign it? Last time she wanted to sign. Yes. The Lawrence case. This is a. I just need. I'll give you.
You're here on James Lawrence.
Yes, ma'am.
All right, is your client accepting the plea?
No, Judge, the last time you were here, you signed the order for blood discovery.
Mhm.
I just delivered a copy of it to the state. I went by the 4th floor window, the discs aren't there. So we're waiting for that discovery.
All right, can I have someone for the state on James Lee Lawrence? All right, so where are we on his discovery?
Judge, I just got a copy, if that's the motion you just filed.
There was
I
an
just-
order.
Okay, when was his motion filed?
The 22nd of, sorry, the April 19th. And then you signed it,
Time when I received it.
yeah, the last docket.
All right, the last time we were here was on May 12th. And on May 12th, we're coming back today for a plea deadline day. So when is he gonna have this? Well, actually, what I have on my docket sheet is on March 9th. We're to come back on April 12th, blood discovery request to be completed, March 9th. So the defense was to file the motion for the blood discovery on March 9th. Obviously, that was not done. So then the defense filed a motion on April 19th. So when will the blood discovery issues be done?
Judge, let me check. I believe it's within 60 days. But let me
Okay.
go. Judge, I believe it's within 60 days, and I can ask them to rush it, make it quicker if possible.
All right, Ms. Ferguson. On James, where's James Lawrence? Where's your client?
Notified.
All right, when Mr. Lawrence appears, put him in the jury box. We'll take this up once your client appears. And he needs to be here by 10. All right, who are the parties on Anna Ramirez?
I am, Your Honor.
Yes, what is happening with Anna Ramirez?
So I had filed a motion to amend the bond conditions. The state is in agreement to amend it to supervised contact. So
Supervised
we can
contact
continue
with-
with the CPS case.
All right, so but where are we on this case?
Oh. As far as trial goes, I have jury duty tomorrow.
No.
Oh.
Today.
Okay.
We're supposed to be here and offer, it's like recall May 16th. Offer to be tendered by state. Defense attorney is also defendant CPS attorney. So has an offer been tendered?
I don't think I'm a judge.
I don't believe so.
All right, so if you all get your offer, then I'll give you your dates.
Okay.
Judge, on Mr. Lawrence.
Mhm.
We were notified that this was not on Zoom on Friday at 3 o'clock.
Mhm.
And so we tried to reach him to let him know that it was live. He's on his way right now.
Okay.
Okay.
Who are the parties on Daniel Montalvo?
Myself and Michael Villarreal.
And what is happening with Daniel Montalvo?
I think we are both parties, I believe, are waiting on some phone records.
trying to double check, Judge.
They may have received them, but they're not available to them yet.
I have on April 18th, it says all discovery received. Reset for May 2nd. And then I have today as a plea deadline date.
I've made a counter offer. There is an offer, I've made a counter. But I'm expected right now at court, Your Honor.
All right, Ms. Ferguson set this for jury trial at the end of May. What date?
June 1. Okay.
All right, where's your client?
He's here. Daniel, you want him to approach?
Yes.
Come on, Daniel.
What page is Daniel want to follow on? Thank you. All right, Mr. Montalvo, your jury trial date is June 1st, and that is also your plea deadline date. The court will not accept any plea bargain agreements after that date, and if you choose not to accept the state plea bargain agreement, then you will be going to jury trial, and you need to be dressed for jury trial on that date. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, if you can give them the June 1st date and let them put on there that it's jury trial, please.
Thank you, Your Honor.
You're welcome.
Good night.
We don't have it.
You don't have it yet?
Yeah, that's.
Thank you. Yes, we thank you. Thank you, Judge. Have a nice day.
Thank you, you too. Omar Madison?
That's my yard.
Yes. Where's Mr. Madison? Where's Mr. Madison? All right, he needs to come forward. All right, what is happening with Mr. Madison? I have here that the defense attorney has, from our last setting, I have defense attorney has video and all discovery. May 16th, the state will make an offer.
Judge, we confer, Marcus.
Yes, Judge. Based on what John is representing to me, there's some.
All right, everyone needs to whisper. Yes.
There's something that I need to look into, where it's a possibility that his client may like not, I guess, may be innocent of the offense, and so I want to speak to the witnesses. Apparently, our victim is unable to communicate, so it's going to require us to speak to other people at the hospital.
Okay.
So just asking for some time to do that.
All right, Ms. Ferguson, on Omar Madison, can I have a 1 month reset? Is that enough time?
Yes.
Are you okay with that date?
Yes.
All right, we're gonna come back on June 21st. All right, you'll get your reset form from the coordinator meetings.
Thank you.
You're okay with that? You know, that's different.
Yeah, and Rogelio Sanchez. Rogelio. Or my Sanchez.
Are you here on Sean?
Yes, ma'am.
All right, yes.
Oh, I just want the court to know that, oh, sorry. Just want to let the court know, I'm conferring on that one, and I think the state is gonna send an offer. There's a very good chance I'll get that resolved today.
Okay.
I do want the court to
So
know.
we can refile that back on the stack. He's gonna
Okay.
approach later on that.
On Angel Cruz, yes, okay, he's in custody. The state have made me an offer. 90% sure that we'll take a plea on that today.
Okay.
So they're gonna bring him up. And on the Rogelio Sanchez, that's a capital judge. The state is in the process of, there's a lot of discovery that they're going to give me. They haven't, they may have it completed, but they haven't given it to me yet. It's gonna be on a disc.
Are they filing this as a?
That's my second thing. They gotta go upstairs on it to talk to Joe Gonzales. So they're not sure yet. So we need enough time for them to go up.
All right,
See what
who's
they're
the
gonna
prosecutor?
do. First and the second, Chief. We're talking about the capital.
All right, on Rogelio Sanchez.
Yes, Judge.
When are you going to let the defense know if you're seeking death penalty? Or not?
Judge, I think it's one that probably we need to go upstairs and do our presentation. I haven't started any of that process because I've been working on discovery on this one, but Judge, if you can give us like a 45-day reset, I can see if I can get that done. To be honest, I don't know what the court, what the admin is doing. I know we're getting close to an election, but you know, this case hasn't been hold up for that. I mean, we still have 9 months or 6 months. Yeah. So I'm gonna present it to them and let them make that decision. But if you give me 45 days.
All right, everyone, make sure you whisper. I'm amazed that when people come before the court to speak, they whisper, but when they're not before the court, they don't whisper. So make sure you whisper when you're not before the court and speak your normal voice when you're in front of the court.
Honestly, aren't as much my problem or your problem. I will present it. If you give me 45 days, let me see what answer I can get.
All right.
That'll be fine, Judge.
Thank you.
Use that other voice and.
I appreciate you. I'm not asking everybody to be very white, but speak up. All right. Ms. Ferguson, can I have a 45-day on Mr. Rogelio Sanchez? All right, we're gonna come back on July 5th.
That's fine,
And
Judge.
so I'm gonna note on my file that the state is to give you an answer on whether or not they're seeking the death penalty.
Okay. And I enjoyed that reference to Barry White.
Start paperwork. Cap to oppose, right? That's what it was.
So I got
It's here.
Yeah.
Yeah, they just need to fix it. Everything is broken. Ms. Ferguson, can you have John Robertson come back, please? Thank you.
Ooh, okay.
So if you can call them, please. I mean, if you want to.
Oh, absolutely.
So I just received that in my stack of documents today.
Okay, thank you.
Yes, do you have your phone?
Well, I don't need it. It's just kind of a.
All right, just one moment. Could you mute me, please? You can put that, that piece on there.
No, I have a standing order to decide. How are you doing?
All right, I cannot complain. It's a beautiful day.
It is. Thank you so much.
Have a great rest of your day.
You too.
Yes, you're here, Miss Watson, Mr. Watson. All right, Mr. Myers spoke to me about this case. He said that there's going to be another case.
I'm off with the case.
No. There's two cases.
Two Andre Watsons.
Oh, there's two Andrea Watsons. Okay, is this the correct Andrea Watson?
Well, one's Andrea and one's Andrea.
So are you here for
You're Andrea,
Andrea?
right? Yes.
I'm Andrea.
Andrea, okay, what is happening with Andrea Watson?
We're still on the jury trial list.
Where's Andrea Watson?
No, downstairs, Judge.
Yes, all right, they're gonna bring your client out.
Listen, if it's necessary for you, okay, but it's not necessary for me.
Oh, it's necessary for me. All right, if you can respond. Ms. Ferguson, can you see if Neil Kappas is still in the building? If you can come back. Thank you. Michael Villarreal, I see. Yes.
I'm sorry, my ears are tearing.
That's okay. Allergies. That may need to be taken up immediately. It's a strong modification issue.
Okay.
And they want to be able to take that into their medical part.
Okay, I'll look at it right now, Judge.
All right, thank you. Brenda, are you ready? All right, who are the parties on Brandon Looking Bill? Court is calling 2022 CR 3149, State of Texas versus Brandon Lee Looking Bill. Can I have parties approach, please? And if you could announce for the record.
Pretty Sparks for the state.
Andrew Fred, Mr. Lucky Bill.
And are you Mr. Looking Bill?
Yes, ma'am.
All right, defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Looking Bill, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled A True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We're waiving the enhancement program.
Any objection?
No objection.
Right.
Your Honor, sorry, we are not waiving the enhancement. I apologize.
That's okay. I was looking, I was wondering.
I wasn't gonna complain, but okay.
All right, Mr. Looking Bill, do you understand that the state is proceeding on the indictment as presented? They're also proceeding on the enhancement allegation. Do you understand?
Yes, ma'am.
All right, and you understand that enhancement allegation is what makes this a state jail felony?
Yes, ma'am.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of evading detention second or more? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
We've discussed it, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Looking Bill, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, your punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine to be probated. State recommends community supervision. They will take in consideration the following county court cause numbers: 651510, 651511, 684157, NIMAC number 659949, and there's to be restitution, if any, in cause number 659949. Say, is there any restitution in this specific cause number?
Not in this one, Your Honor.
All right. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There be 200 hours of community service restitution, a TAP evaluation, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, Judge. State offer states exhibit 1 and all attachments.
No objections, Your Honor.
All right, Mr. Lookingbill, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Judge, we should ask you to follow the plea bargain.
All right, Mr. Lookingbill, are you employed?
Yes, ma'am.
What do you do?
I'm self-employed. I'm a carpenter.
All right, I'm gonna need you to speak up. You say you're a carpenter?
Yes, ma'am. I'm a carpenter.
Did you go to school for that?
No, ma'am. I'm not a licensed carpenter. I work through my uncle.
Do you have any children?
Yes, ma'am.
What are their ages?
5, 4, 3, 2.
All right, you missed one. You did 5, 4, 3,
Oh,
2,
what?
1.
Yeah.
Is there one on the way?
Yeah, there's one on the way.
Okay, so 5, 4, 3, 2, and 1 on the way.
Yes, ma'am.
Are you under child support orders?
No, ma'am.
Do you see your children when you're not in custody?
Yes. Every, not it's not like I'm supposed to, but yeah, I get to see them every, like birthday, like Christmas, stuff like that.
Okay, how far did you go in school?
10th grade, man.
Why did you drop out after 10th grade?
Because I didn't have a mother or father to keep me there, to push me forward, to keep moving, like, to keep me, my back support growing up.
So how old are you now?
I'm 26.
Was child protective services involved?
With my family, me, no.
With your family?
With my kids, no. Not recently.
Okay, so they haven't been involved with your children recently?
No, ma'am.
When's the last time CPS was
As
involved?
far as I know, I don't know. I know I have full custody of them.
Where
Well, I
did-
have my rights in other words. Sorry.
All right, so let's back up a little bit. So was Child Protective Services ever involved with your children who are ages 5, 4, 3, 2, and 1 on the way?
No, ma'am.
All right. So what's your drug of choice? Your drug of choice?
Methamphetamine.
Okay. How often were you using?
Every other day. But I am, I got it under control.
Well, I mean, you have it under control because you're in custody.
Oh.
But here's the thing,
Yes, ma'am.
I just need you to be honest with me.
Yes, ma'am.
Usually when people have drug issues, I give them a chance to see if they can keep it under control. You
Yes, ma'am.
understand? All right. Yes.
Thank you.
May I interrupt for a brief moment on that
Yes.
issue, Your Honor? We talked about this earlier, Brandon. You had told me that you had looked into lifetime.
Yes, ma'am. I mean, yes, yeah.
So you had inquired into that, and that was something that you and I were going to talk about. Based on what the TAP evaluation comes back at, Judge, we'd like that as an option. If they were to recommend inpatient treatment, he has talked to them. He does have that as an available option if the TAP evaluation comes back recommending inpatient.
Right. So who are you living with?
Right now, my sister.
With your sister? Does your sister use any type of?
No,
controlled
ma'am.
substance?
She's already got like 3 PhDs. She just
3 PhDs.
Well, I don't know how mentally I don't know how the school works. But
Okay.
she's a good kid now.
All right, do not bring drama and trauma to her doorstep.
No,
You
I do not.
understand?
That's one thing I do not do.
All right, so this 9 state that you're dismissing, what is that constant? What is that case?
It's an unauthorized discharge.
Okay. So, and who is the defendant you were with in this? Charles Lundgren.
Charles Landry?
Yes.
I'm sorry, are you referring to the evading case? Or
Yes, the evading case. Who is this? A friend? Who is he?
Yeah, it's a friend.
All right, and then in the other case, was there some other defendant involved in that?
He was the only one in the vehicle.
Okay.
Oh. Yeah. Sorry, my bad. I tried to know.
All right, any other questions from the state of the defense?
There you go.
What are these tattoos about?
Nothing, ma'am. Just a scare tactic. I was bullied as a kid. I was really bullied as a kid. I used to be a little fat white boy.
So what's the neck?
The neck tattoo is nothing. It's just Medusa.
All right, and was that painful?
No, ma'am.
Who put that? Was that a professional who put that on or
Yes,
usually?
it was a professional. My cousin was a professional. I got these professional done.
No, you're telling me the Medusa tattoo, that's professional work?
No, ma'am. This is street work.
Okay.
It's just not done yet. But yeah.
All right, and what's the name thing that's happening on the chest?
Dusachi is / Versace, but I can't.
I'm sorry, what does it say?
Dusachi, but it stands for Versace. I just didn't put spell it on. They spell it wrong.
Wait, how are you spelling Versace?
Dusachi, DUSA. Because they call me Dusa, but I can't use Versace, so
Because of copyright issues?
Yes,
Is
ma'am.
that what you're telling me?
Yes, ma'am.
All right. So this is what the court is going to do. Sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's to be intensive outpatient treatment. I'm going to start you with that first. We'll see how it goes. The UA hotline. Parenting classes. And do the triple T, I think that's what it is, Ms. Reyes. Cats 1 and 2. Cats 1 and 2, my understanding, that's the theft course. I can give you that class in 10 seconds. Don't steal. Don't take what doesn't belong to you. People work hard for their stuff. They don't like when other people take it.
Yes, ma'am.
As far as taking vehicles are concerned, when you steal a vehicle, that's someone's sanctuary.
Yes,
Right?
ma'am, I
And
understand.
they don't like passengers in their vehicle, people driving their vehicles when it's not theirs. You understand?
Yes, ma'am.
And what is the tattoo on the beard thing? What is that?
It's just, I don't know, I'm supposed to continue it. You know, when Ripley's, believe it or not, started doing the thing to be who you are and not be scared, I just wanted to, you know, I don't know, I have a whole bunch of tattoos.
Okay, well, with all the tattoos, you may be limiting your employment opportunities.
Yes, ma'am, I do understand that.
I'm gonna want a gang evaluation. $1,000 fine probated. Take in consideration county court cause numbers 651510, 651511, 684157, night mag number 659949, restitution, if any, and night mag number 659949. 200 hours of community service restitution. The court will waive 40 of those hours if you provide proof of your COVID vaccination. The court is not requiring you to get COVID vaccination, but if you've had it, and that includes the full regimen with the booster, if you've had it, tender it to probation. You have 40 hours deducted. Again, if you don't want to do it, if you don't have it, that's completely up to you. Proof of full-time employment. And this full-time employment is not you self-employed. You're gonna have to find a job where you work 40 hours a week at least. You understand?
Yes, ma'am.
You have 4 children and one on the way to take care of.
Yes, ma'am, I understand that.
All right. So full-time employment, there's to be no employment as a home health care provider with minors.
No, ma'am.
And he's to have full-time employment within 30 days. There's to be no unsupervised contact with minors. So that means you are not to be babysitting, you're not to be doing anything. And if you have your children with you, there needs to be an appropriate adult chaperone present. Do you understand?
Yes, ma'am.
When he completes parenting classes, because you must complete that, the court will waive the remaining of your community service hours. I'm gonna want field visits, random, 3 times per month. Rebecca, is there anything else that he needs?
No, ma'am, I think you got everything.
All right, Mr. Lookinville, is there anything else that you need from the court in order to be successful in this probation?
No, ma'am.
All right, is there anything from either party with regards to sentencing?
Nothing further, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that? Okay, is this the correct trial court certification form? I don't think it is.
Got it over there.
There are 2 or 3 that are floating around. Yes.
Judge, what's the cause number?
It is 2022-3149. Yes. Thank you. Mr. Lookinville, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Lookinville, Bill, good luck to you. We can go off the record. All right. You have to start making better decisions in your life. You have 4 children to take care of. You have 1 on the way. And right now you're off to a poor start because you don't have any employment to support any of your children. And last time I checked, a 5, 4, 3, and 2-year-old can't take care of themselves. We have child labor laws now.
Yes, ma'am.
So they can't work. You can't just put them in Travis Park and say, good luck to you. So when you bring children into this world, you need to take care of them. And that's more than just, I love them. You need to take care of them financially because they need to eat, they need to have clothes, and they need to have shelter. You understand?
Yes, ma'am. I
So
understand.
be a better father so that they can look up to
Yeah,
you.
thank you, thank you.
All right, good luck to you.
Judge, if you can just wait in there and I'll be out there shortly.
All right, thank you. Has your file been pulled?
No, it's just on MTR that we had this afternoon. It's a motion for continuance.
You need to have a file pulled.
Okay.
All right, who is the person on Shamarcus Porter? Who's that? Somebody put this up here. Okay. It's ex parte. Who is the interpreter here for?
Judge, I'm just going over paperwork with
Okay.
Mr. Hernandez, but I should be ready in about 5 minutes.
All right. All right. All right, so whenever they're done, just do those to be straight away.
She is my client.
Who's the person on Angel Gonzales?
Judge, that's me as well, and I did submit an ex parte
Yes, I
motion
have
to the
that, so
court.
we'll discuss that after we finish.
And there's also, I brought another off docket ex parte motion for you.
All right, who's on Christopher Rodriguez? Yes.
Judge, we're set for a plea deadline today. I had an opportunity to meet with the client and to go over the night case discovery. We want to see if we could just give a week extension of the plea deadline, please.
All right, where's Mr. Christopher Ackley? If you could approach, please.
Connection.
All right, what page is Christopher Ackley on? Yes.
It's on the report.
Thank you. See, I was looking for Christopher Ackley. And what is the night case?
What is the NIMAC number?
No, what is that charge?
It's a drug charge.
All right, Ms. Ferguson, can you set this next week for jury trial, please? All right, so we're coming back on the 23rd for a jury trial.
Okay, Judge. Will we be excused?
You need to get a reset form from Ms. Ferguson.
Thanks.
Oh, there's other files.
All right, Ashley Castillo.
I think it'll be better.
Oh, he already came in.
In case you're looking.
Yes, he came back in. Yeah, no problem. It's happening. It's a Monday. That's okay. All right, Ashley Castillo, my understanding is I have a dismissal.
That's correct.
All right.
It was actually set tomorrow, but took care of it.
Okay, well, I hope you have learned from this process.
Yes, ma'am.
Did the neck tattoo hurt? That's my question. And what is it a tattoo of?
It's an angel.
Right, was that painful getting that on your neck?
Yes, ma'am.
Did you ever think, hey, I'm gonna stop, and you're like, I'm in, I gotta finish it?
I gotta finish it. Once I start something, just finish it and get it done.
All right, good luck to you. Be better. Don't come back here unless you're coming back for a visit to say hello. You understand?
Yes, ma'am. Thank you.
All right, good luck to you. Please. What do you have? All right, Andrea Watson. Hello, Mr. Watson. And I will tell you, I admire the fact that when you come into court, you're always dressed appropriately. When you're on bond, you're dressed appropriately. When you come from the jail, you're dressed appropriately. So I want to let you know, I appreciate that. So, Mr. Watson, what we're going to do is we're going to bring you back tomorrow for your jury trial, okay? So we will have you back here and you'll be dressed for trial. Do you have any questions? All right. Yes, thank you. Yes.
We didn't have that Watson set. We have the other Watson that was set for tomorrow.
No, he's on the docket today.
No, but for trial tomorrow.
Yes.
You did sign it.
That's parties ready. All right, Mr. Jimenez, are you ready on Mr. Cruz?
Yes, Judge. Ryan Boomer and I will approach, if that's all right.
Sure. And where is Mr. Cruz? Cruz down?
It's a-
Was he
sorry,
not
Mary,
called over?
Yeah, he should have been. So downstairs, two downstairs.
Okay. All right, so when you're ready to proceed, you have to ask for Mr. Cruz.
Well, it's just on a motion for continuance, Judge.
He needs to be here for that.
He needs to be here for that?
Yes.
Okay, so,
She's calling downstairs.
great. Thank you.
May I approach you on Anthony Bennett?
You approach and get the,
Yes, ma'am, it should be in there.
I don't have the file, Mr. Bennett. All right, and so that everyone knows, when you approach, if you'll get the file from the clerks will put it in and you will appear in order that the clerk has placed it on. So there's no need to approach me because then people are skipping out of order. All right, Mr. Bennett.
He is incompetent, Judge. He's awaiting a treatment bed.
Ms. Ferguson, can you see about an update on when there's a treatment bed available for Mr. Bennett? And we'll need a reset on that. All right, we'll come back on June 27th at 9 a.m.
Thank you, Judge. May I be excused?
You'll need to get a reset form from the coordinator, then you can be excused.
Yes.
All right, Juan Cuellar. Yes.
Judge, I received that email on Friday, but I was out early for a doctor's appointment. I had the wrong number for my client. I got the right number from pretrial, and he can come in tomorrow at 9 a.m. if the court would allow him to do so.
He needs to be here this afternoon. He needs to be here by 2. Because we have an issue, and if you want to speak with pretrial services, he doesn't have admission interlock.
I will
So,
try to get him here.
2
Judge.
p.m.
Thank you, Judge.
You're welcome. Here's this one. It's gonna come back at 2 p.m.
One more solo, MTL. There's no need for a term.
Yes.
Judge, this is an MTR. I don't know if you recall this case or not, but Michelle and I agreed to a bond on this case a couple weeks back for her to give birth to a child. And you had a lot of reservations, concerns about it. She's on GPS tracking. It turns out that they actually allowed her to deliver the child with GPS tracking as the jail did not release her without the tracking. So I know we talked about that. They would not let her do it. Anyway, she ended up having the child. Child is doing well. We're asked for like a 3-week reset, Judge, and here's the reason why. The court had ordered that she be tested through pretrial services. That has not happened yet. Pretrial is not, she's being tested through CPS, but not the pretrial services. So we want to get some negative UAs in there, Judge, prior to the court making a decision on how the case can proceed. She's also not being tested for probation either. We're hoping that there would have been some UAs by now. She can test it today if the court wants her tested today.
All right. Was she late today?
She was late by 10 minutes, Judge. She's put in the box.
Why was she late? Miss Arizola, come forward, please. Is there a reason you were late today?
No, ma'am. There's I just had I'm breastfeeding the baby, and I had to pump a bottle before I left, and I just was running late.
Okay. All right, Rebecca. All right, who's the prosecutor on this?
Michelle Hayden.
Ms. Hayden, do you know whether or not on this motion to revoke you're asking for revocation?
Judge, I was inclined to, but then defense did say that they had these proof of negative UAs and other items they wanted to provide. I know she just had the baby, so I said I would consider those things.
All right, then let's proceed with the motion to revoke.
You want to do it today, Judge?
Yes.
Can we set up for contested hearing then, Judge?
The state is already stating they're not seeking revocation. What are we contesting?
I'm not sure, Michelle.
Well, Judge, I said I was inclined to. I'm saying I would reconsider with that.
Judge, part of the concern is when she's at the hospital, CPS did get involved. The child was released to her.
Yes, they would.
Yes.
And I told you all they would.
Right. The child stayed in the hospital for an extra day or two to make sure everything was good before the child was released to mom and dad. The child is with mom and dad now. But she. Okay, so the baby's dad does not live with him, Judge. But baby's dad is involved. That's actually hardly in the case, but the child and the mom were both tested, both came back negative at the hospital. That's one I'm trying to get to Michelle in the court, those records, which I do not have. She also been tested through CPS and apparently that UA was clean. I need to get that to Michelle, which I do not have. I think Michelle's decision was based largely in part on those UAs. If they're clean enough.
All right, so can't someone just call the CPS worker? Let's call the CPS worker. They already know you the results.
Okay, we can do that. Judge, do you want it done today or?
Yes, we can come back at 2 p.m.
Okay.
Judges, Ms. Arzo, free to leave, and be back at 2 then. She could leave
At
right
2 p.m. Yes. All right, can I have the parties approach on the Jamilius crew? Oh, no, no, no.
Oh, just
There's a
for me?
reason I wrote this down.
Okay, sorry.
No. All right, so on Jamilius crew,
Yes, Judge.
you gonna need to speak to your client because he will be forced to come out for jury trial. You
Yes,
understand?
I'll let him know. I had no idea that this was gonna happen. I saw him just yesterday.
So what is the issue?
This is a motion. I don't. Yes, Your Honor. Well, two things. You said that he will be brought for jury trial. I think.
Just 1 second. Let's go on the record, Brennan. Okay. All right, the court is calling 2017 CR 12785, State of Texas versus Jamilius crew. Could I have the parties announce for the record for the state,
Ryan Groomer for the state of Texas.
for the defense?
Eduardo Jimenez.
All right, we're here. Defense, you filed this motion for continuance in 2017 CR 12785. Are you asking for a continuance in all your cases?
No, Your Honor. This is would be the MTR that he's facing. He's also facing trial for a new number 1, but this would be the MTR that he was scheduled to appear at 1:30 this afternoon on the MTR. I think both the state and the defense have reasons to ask for continuance. So in that sense, it would be an agreed continuance. But on the defense's side, we don't have all the discovery yet on the new number 1, which is going to be enveloped in the process of the MTR. So that's one reason why we're asking for the continuance. The second reason is that this is an old case and the probation officer he had no longer works for probation or pretrial. So we need to locate that person to be able to subpoena them or him. Those are the two reasons why the defense is asking for the continuance. And then I think that the prosecution has some reasons as well why they were asking for a continuance.
All right, so with regards to the cases that are 2020 cases,
Yes, Your Honor.
those are trial ready. So when are we going to trial of those? Let's move aside from the motion to revoke. Let's talk about the 2020 cases.
From the defense's side, just a little bit more discovery and the ability to, as I say, it's the same reasons actually as the MTR, because we're basing it on the new number 1, which are that I think they indicted him. I lost count of how many cases, is it 17 or so, Your Honor? But it's all rising out of the same incident and occurrence, an alleged shooting at a nightclub. And so as far as that, we're preparing for trial on that, and we would just need full discovery. There's just a few things missing from discovery. And then the ability to, some time to locate the probation officer.
All right, Ms. Ferguson. Can you schedule this for the jury trial in July, please? And if you put it on, is July 6th enough time for everybody?
I think so from the state's perspective, Judge, yes.
Just from the defense as well, Your Honor.
It'll be July 5th. All right, it'll be July 5th.
July 5th, okay.
So that's when the jury trial will be. And for the record, Mr. Crew did not want to appear today. Is that correct, Mr.?
That's what I was told by the bailiffs, Your Honor. I had no understanding that he was not coming today. I just saw him yesterday, in fact, in the Bexar County Jail in person.
All right, so your client will need to be dressed for the jury trial on July 5th.
Yes, Your Honor.
He will be brought over in whatever clothing he has at the jail, as you know. So if there's some issue with regards to the clothing exchange, let the court know, and we'll see what we can do to expedite it.
Yes, Your Honor. Thank you.
So your jury trial then will be scheduled for July 5th.
Yes, Your Honor.
All right. Yes, Bill, give you a reset form, Mr. Jimenez.
All right, thank you. Maybe it's easier now.
Yes, have you signed the reset
The
form?
reset form. Okay.
Yes.
On this motion, Judge Paper.
Oh, yes.
We can agree to partial, just allow her to do all the appointment stuff. I read the motion, I'm not really sure what exactly they're asking for, but that's what we
Well,
can
I'll
agree
do
to.
partial for medical appointments in school.
Okay,
All right,
thank you, Judge.
Thanks for looking into that.
Well,
Jury trial. Mr. Jimenez, you're going straight to jury trial.
okay, yes, thank you.
You're welcome. All right, are the parties ready on Andre Watson? And defense, is there only one case?
Yes.
Right, and for the state, court is calling 2021 CR 8488 State of Texas versus Andre Watson. Can I have parties announced for the record, please, for the state?
Marcus Sanders.
For the defense?
Robert Mount for defendant, Your Honor.
And are you Mr. Watson?
Yes, I am.
Defense, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case, and did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Watson, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, I did.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I'm waiving paragraph A, proceeding on paragraph B.
That's your understanding, Judge.
Any objection?
No.
All right, Mr. Watson, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
I did.
You understand you're charged with burglary of a habitation force. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, I do.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
I did.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty, not grant you community supervision, and sentence you up to 20 years of prison and up to $10,000 fine. Did you understand?
I do understand.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge. And for the record, he was evaluated and found to be competent. So I have no questions about his competency.
Right. And do you believe that he was sane at the time of the offense?
I did.
Mr. Watson, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
I did.
According to the plea bargain agreement, state is proceeding on paragraph B. Punishments to be assessed at 4 years in the prison. There's a $1,000 fine. State opposes your application for deferred adjudication. The state recommends community supervision. There's to be restitution to Erica Hawkins, ERICAHAWKINS. And there's to be no contact with Erica Hawkins or the address that's listed in the plea bargain agreement. Did you understand that?
I do.
And did you understand that to be your plea bargain agreement?
I go to prison before? No, that's how she said. That's the conviction or the term we're applying for deferred. Yes.
Right, so did you understand that to be the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
It is, Judge.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do.
Counsel, have any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 150 hours community service restitution, and mixed file evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I do.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, the state offer states Exhibit 1 and its attachments.
No objections, Your Honor.
Mr. Watson, I'm showing you what's entitled waiver, consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Judge would ask to proceed to that.
All right, anything you wish to say on behalf of your client?
Judge, my client's been incarcerated for 329 days. The state and I think, made an attempt to resolve the case. There were some issues with some evidence that the police had not taken from the apartment complex that I think kind of led to us resolving the case this way. Some videotape evidence that would have, I guess, given us conclusive evidence one way or the other. My client has, as far as I can see, no prior felony convictions. I think he has 1 prior felony arrest for a burglary of a building back in 2008. And everything else looks like misdemeanor theft charge or driving while license invalid. I do think he would be a good candidate for deferred. I would ask the court to grant him that. I do think to make my affidavit would be a good idea. I would ask the court, based on the time he's been incarcerated, to probate his fine and his community service hours. He works as a barber when he's not in custody. And I think obviously he needs to get back to work to support himself. And he plans to ask the court to let him move. He has family in Ohio, but he has a job waiting for him in El Paso, Texas, if the court would grant him permission to move back there once he's released.
All right, so where is he seeking to go? Ohio or El Paso?
El Paso.
Trying to do him a driver's
All right. State, does Mr. Watson have any felony convictions or?
No, Judge.
So you're asking for regular probation. Is that just based upon the nature of the offense?
Correct, Judge. And the facts.
All right, Mr. Watson, do you have any children?
No.
So if you're released today, where would you be staying?
I will go right now. I have a referral to, I completed 2 years of in treatment recovery program over there. So
over where?
At Haven for Hope.
Okay.
So I will stay there just until I'm sure that I have everything in line for me to go to El Paso, meaning my ticket for the Greyhound or the flight, to make sure I get everything in order for me to go there.
All right, you understand you're not transferred until
Yes.
they accept your transfer. Thank you. You understand that?
Yes,
And have you ever been diagnosed before?
no,
Have you ever seen a psychiatrist or psychologist or anything?
no,
Has anyone ever suggested to you that you
No.
need to see a psychiatrist or psychologist?
just until this case.
All right, is there any restitution?
Not that we're aware of, Judge.
All right, this is, since you're saying that you're gonna be staying at Haven for Hope, then I'm gonna order that he stay at Haven for Hope. If there comes a point in time where you are allowed to transfer to El Paso, then you can leave there. Or if you want to move somewhere else, then you'll need to ask probation for that, and probation will come to me. But you're not allowed to change your residence from Haven for Hope. You understand?
Yes,
Now, when you get out, if there's an issue that there's no placement available at Haven for Hope, you still need to let probation officers know.
yes, ma'am. So today, when I go straight over there and then figure it out. what-
Probation is going to give you all the information you need. Is that correct, Rebecca? She's saying yes.
Yes, ma'am.
Okay.
All right, this is what the court is going to do, Mr. Watson. Mr. Watson, the state is asking for 4 years with a conviction. So you can either take the 4 years with a conviction, or either I'll place you on 5 years deferred adjudication.
I'll do the 5-year.
Okay. All right, the court, as previously stated, could someone turn off their phone, please? As previously stated, the court is finding that it's sufficient evidence to find you guilty of paragraph B. The court will defer finding of guilt, give you 5 years deferred adjudication. There's $1,000 fine that'll be prorated. There's to be restitution, if any, to Erica Hawkins. Mr. Mauer, if there's an issue over the restitution amount, you can always come back to the court and we can hear that.
All right, thank you, Judge.
There's to be no contact with Erica Hawkins or the residents. And Rebecca, I'll type the residence address for you in the chat box.
Thank you, Judge.
And what is the name of that apartment complex? I didn't see it in the skips.
Hidden Village.
Hidden Village? All right, you're not allowed to have any contact with the Hidden Village apartments, you understand?
Yes, ma'am.
So there's to be no contact with the address that I just put in the chat box to you, Ms. Reyes, and it's also in the plea paperwork, or the Hidden Village apartments. There's to be a transfer to El Paso, Texas.
Yes.
150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring anyone to get the COVID vaccination. But if you haven't, and that includes the booster shot, then 40 of those hours will be waived. You understand? And do you actually have your barber's license?
Yes.
Okay. There's to be a MIC evaluation. And Ms. Reyes, if the evaluation for MIC is for treatment for Mr. Watson, then what I'll do is I'll waive the remaining of the community service hours as long as he stays in compliance with MIC or MIA. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider with minors. Defendant is to reside at Haven for Hope until transferred to El Paso. Robert, that's not your client.
No.
All right. There's to be regular reporting in person or by Zoom. We'll do field visits, and this is just a field visit to check to make sure that he's still at Haven for Hope. So that'll be field visits 1 time per month. And that'll be regular. Rebecca, is there anything else that he needs?
No, Judge, is he gonna do the make my off eval in custody, or is that out of custody?
That'll be out of custody.
Okay, thank you.
So, Mr. Watson, here's the thing. I'm letting you out of custody because you've been in custody for a long time. If you miss any of these appointments, what's going to happen is a motion to revoke is going to be filed. And when I receive that motion to revoke, if it appears to be in proper legal order, I'm going to sign it. And then a warrant will be issued for your arrest. And you'll be placed back in custody. And either you will make bond or not make bond. You understand?
Yes,
So
ma'am.
you need to make sure that you make all of these appointments.
I will.
All right. Anything else, Rebecca? All right, Ms. Watson, is there anything else that you need from the court in order to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do.
All right, Mr. Watson, good luck to you. We can go off the record. So what neck tattoos do you have?
It's just a tribal.
Was that painful?
Of course.
And people just keep going.
That's it. That's it.
All right, thank you. Just have a seat of probation. We'll go over conditions.
Probation will come talk to me.
Yes.
Thank you.
You're welcome. All right, who are the parties on Hernandez? And is this in Spanish?
It is, and we have an interpreter.
Thank you. Is your client a U.S. citizen?
No, he is not.
All right. So if we can have Mr. Hernandez come forward, please. Efren Thomas Hernandez. All right, the court is calling 2018 CR 11066, State of Texas versus Efren Hernandez. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Kathy Compton for Mr. Acknowledgement.
And are you Mr. Hernandez?
Yes.
All right, we have an interpreter here. The interpreter, if you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, yeah.
All right, you can lower your hand if you could state your name for the record, please.
Arlene Abrams, license number 2081.
Mr. Hernandez, all the documents I'm going to speak with you or ask you questions about are in English. Were those documents explained to you in Spanish?
Yes.
All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. All right, Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney in Spanish and did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
No, Your Honor. State's proceeding on the lesser included offense of assault causing bodily injury to a family, married or cohabitated, class A misdemeanor.
Any objection?
No objection.
Mr. Hernandez, did you review a document with your attorney entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney in Spanish? Did you understand it and did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation as a Class A misdemeanor? The range of punishment for that offense is up to 1 year in jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow that plea bargain agreement. If for any reason the court does not follow that plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
We've discussed the case, Your Honor, and yes, we've discussed those.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Hernandez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel. My understanding is that you are versed in immigration law.
That's correct, Your Honor. Just for the record, I am a board certified criminal attorney. I also have practiced immigration law for many years. And I did discuss the immigration consequences with my client. I did inform him that this type of case will render him deportable, excludable, and as the law exists today, he would not be able to ever at any point enter the United States legally again.
All right, Mr. Hernandez, did your attorney advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
Yes.
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes.
Do you understand the consequences of entering a plea as it relates to your immigration issues today?
Yes.
And Ms. Compton, do you believe that your client understands the consequences of entering a plea to this charge, his immigration consequences?
Yes, I do.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Mr. Hernandez, did you review a document or page entitled Plea Bargain with your attorney? Did you understand it?
Yes.
According to the plea bargaining agreement, the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation. Punishment is to be assessed at 263 days in the Bexar County Jail. There is no fine, there are no applications, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to own? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
All right, did you review the paragraph entitled Waiver of Appeal with your attorney? Did you sign it in both places?
Yes.
And did you understand it?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Council, are there any such motions?
There have been none.
Then to the offense of assault, bodily injury, marriage cohabitation as a class A misdemeanor. How do you plead? Guilty, not guilty, or no contest?
No me opongo.
No contest.
State any evidence to support the plea.
Yes, sir. At this time, state offer states exhibit number 1 and its attachments.
No objection.
Mr. Hernandez, did you review the document entitled Waiver of Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We're asking that you do so, Your Honor.
Anything you wish to say on behalf of your client?
We would just request you follow the plea bargain agreement.
All right, the court then will sentence you to 263 days in the Bexar County Jail. There's an affirmative finding of family violence. Are there any no contact orders, state?
Your Honor, my understanding is that the complaining witness originally, that they have reconciled to the point of where my client is living nearer on the other side of the border in Mexico. He's moved to be closer, and although they are not together, they are still co-parenting, and she actually does bring the children so they can have time with their father. So I think that they've been doing a great job so far of co-parenting after this, and I would just ask that they be allowed to continue to do that.
We haven't had contact with her in a little bit of time. It's an older case. So I can't speak to any of those issues, but I have I don't have any reason to believe that Ms. Compton is misinterpreting those facts.
Is this to be a judgment satisfied?
That is a contemplation of the party.
All right, the court will show that the judgment is satisfied. Mr. Hernandez, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney in Spanish and did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, Mr. Hernandez. We can go off the record. Mr. Hernandez, obviously you should not be drinking alcohol. You should not raise your hands to people you love. Do you understand?
Yes.
Know better, be better. All right, thank you.
Thank you, Your Honor.
You're welcome. Who are the parties on Valdez?
Judge, before you move on.
Just 1 second.
I did have Mr. Gonzales here. That was the one that I had submitted the ex parte motion on.
Angel Gonzales?
Yes.
Okay.
And I just wasn't sure.
Okay, just give me a moment. Let me look at that. What is the charge?
Murder.
Okay.
And I have conferred this morning with Ms. Hayden. I don't believe that the state at this point is prepared to make an offer. I know that we've recently received some new items of discovery on the case. She and I both, I think, need to review those before we confer again.
All right, and where's Mr. Gonzales?
He's here. He's seated over in the jury box, Judge.
All right, Mr. Gonzales, if you can come forward, please. Thank you, Judge. All right, Mr. Gonzalez, my understanding is that both parties need some more time to review discovery. So what's gonna happen is we're gonna come back in 30 days to see where they are in their discovery. You understand?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right, Ms. Ferguson, can I have a 30-day reset on Angel Gonzalez, please? I'll put that down as discovery. All right, so we'll come back on June 2nd.
Thank you, Judge.
All right, thank you.
Can I get a copy of that order before they?
Yes, if you'll
seal
take it
up?
to the back to the clerk, and then we'll take care of that.
And then I had Shamarcus Porter, but that's off docket, so I didn't know if you wanted me to just check back later this
Yes,
week
you can
with
check
you.
back. Well, you can check back later today.
Okay, working on an appeal, so I'll probably call in and see what your decision is.
All right, no
Thank you.
problem. And Gonzalez can go back. All right, the parties on David Valdez.
Never yet.
No. All right, the court is calling 2021 CR 3954, State of Texas versus David Valdez. May I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Joseph Stateson.
And are you Mr. Valdez?
Yes, ma'am.
Defense, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did and I have.
Court will find that the state is in compliance with discovery. Mr. Valdez, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Valdez, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently confident was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Valdez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. The state opposes your applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Yes, and to be specific, it was, I believe, a cap of 2, and you were within the range at your discretion, Judge.
Is that correct?
It is, Judge.
All right, any objections to the state making a notation that it's a cap of 2 years?
No objection.
All right, and if you all go.
Sorry about that, Judge.
That's no problem. Oh, I'm sorry, because the initial. All right, then, if you understand your agreement was a cap of 2 years, Mr. Valdez?
Yes, ma'am.
All right, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There are not.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State would offer State's Exhibit 1 and all attachments.
No objection.
Mr. Valdez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after viewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing or not?
Judge, is that, if you request a PSI, we understand that, but we would like to go straight to sentencing today.
All right, then the court will hear argument. State, you're requesting that his application be denied. Is there a reason?
Yes, Judge. In his criminal history, I believe Mr. Valdez, I believe it was in, I may need to double check, but I think it's within the past 5 years. He was placed on probation for the same type of offense. He was not able to successfully complete that. That probation was sentenced to 14 months in state jail. Judge, I think that the majority of his other criminal history is not related, but I think what's most evident is he's been on probation before for stealing motor vehicles, and yet he's here before the court again for stealing motor vehicles, and he's asking for probation again. Judge, I think that we should learn from the lessons of the last time that he tried probation on this offense is that he deserves state jail and not probation.
All right.
Judge, prior offenses that the state mentioned, a lot of the prior ones he had were rejected or dismissed cases. He did have a 2017 unauthorized use of the vehicle. He did go to state jail facility. We're asking to get deferred probation on this case, Your Honor. While he's not contesting it, he's asking for probation because he has had priors before. None were first degree convictions, never been to TDC, no second degree convictions. He is a licensed plumber. I believe he's a good candidate for probation. He was at one time homeless before this happened, and he doesn't want that lifestyle anymore. He's living with his mother. He does have 2 children, but they're both grown adults. They do have children of their own, so he's a grandfather. But he believes that he can get work in the plumbing field, pay off fines, do community service. He would really like a chance to have probation, Your Honor.
All right. I'm concerned because I've read the stipulations, Mr. Valdez, and in the stipulations, not only did you steal a vehicle, you were working on the vehicle as though it were your vehicle, and then a video was produced showing you actually driving the vehicle. So why are we taking things that don't belong to us?
I was homeless, ma'am, and
That's no excuse.
yes, ma'am.
I mean, does being homeless give you a pass to steal cars? No. Stealing cars is against the law. Does being homeless give you a pass to break into people's homes? No. And there are plenty of other places here. So we're back to the question of why are you stealing the vehicle and working on the vehicle as though it's your own?
It was a mistake I made, ma'am.
Nope, it's not a mistake, it's a choice. You know what a mistake is? Brenda, are you ready? This is what a mistake is. I check the weather report. They tell me it's gonna rain. So I bring my black umbrella to the courthouse. It rains. There's a person sitting next to me. They have a black umbrella. I get ready to leave the courthouse. I grab a black umbrella because I brought a black umbrella. When I go outside with my umbrella and I open it up, I see initials on it. It's not my initials. That's a mistake because I thought that was my black umbrella. You made a bad choice. And let me just tell you what a bad choice is. I don't know it's gonna rain. I didn't check the weather report. My mom didn't call me and tell me it was gonna rain. So I come to court. I don't have an umbrella. And somebody says, Stephanie, it's raining outside. And there's an umbrella next to me. And I take that umbrella and I go outside with that umbrella, go on my way. That's not a mistake. I didn't bring an umbrella. I didn't know it was gonna rain. I just decided to steal it because it was raining. So you haven't made mistakes. You've made choices.
Yes.
I just find it very bold to steal a vehicle, do repair work on a vehicle like it's your own. That's a problem. And how old are you?
49, man.
49, you're old enough to know better. All right, I'm gonna deny your application. Does anybody want to speak to the cap?
Judge, I can briefly judge. 14 months was what he was given on the last theft of a vehicle. And obviously that was not enough for him to stop stealing vehicles because we're back here again a few years later, Judge. We'd ask for you to start at 14 months because that was the amount of medicine he was given last time for his behavior. And obviously it didn't take because we're back before another judge with another stolen vehicle.
Defense?
Judge, if you could consider that the vehicle was not trashed out, it was not abandoned in a ditch. There was no crash. There was no restitution as far as nothing was scraped. No parts were removed. It wasn't sawed off parts to sell. As far as punishment, sentencing on the lower end discretion, considering that he's never been to TDC, he just had one prior state jail trip. We're asking somewhere between under 9 months, Your Honor.
All right, Mr. Valdez, what do you think you deserve?
State jail, man.
No, I mean, you're going to the state jail facility. My question is, how much time do you think you deserve? So I can sentence you anywhere from 180 days up to 2 years in the state jail facility. How much time do you deserve for stealing someone's vehicle?
2 years, man.
Oh, well, thank you for, why do you deserve 2 years?
It is the second time I've done it.
Okay. All right. Court will sentence you to 1 year in the state jail facility, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Valdez, you got to start making better choices. Otherwise, you're going to look up and find yourself the oldest person in TDC or the state jail facility. You understand?
Yes, ma'am.
So what will end up happening is when new people come in, they're going to say, how does this place run? What are the rules I should know about? And you know what they're going to say? Ask the oldest person here. And they're going to say, who is that? And you know what the answer is going to be? Oh, Mr. Valdez. We call him Grandpa Valdez. Don't be that person at the prison or the state jail facility who's the oldest person there. You understand?
Yes, ma'am.
Now, what's up with all these tattoos? What's up with the side forehead tattoo?
It's dumb choices I make, man.
Was it painful?
Yes, ma'am.
Did you think of stopping?
I was kind of in the middle of it already. I just finished.
Okay. All right. Good luck to you, Mr. Valdez. All right. This says Spanish speaker, but we don't have an interpreter. Hi. So who are the parties on Alessandro Calderon Martinez?
Judge, on this one, can I approach a little closer up or off the record? Pre-discussion before we call.
Sure. All right, could you mute me, please? All right. Hi.
Okay, I was gonna give you a quick announcement.
Okay, just give me one moment.
Sure.
All right, so we're here on Alessandro Calderon Martinez. And it's my understanding that the state and defense are asking for continuance. Is that correct?
Yes, Your Honor, we'd like to set for the purpose.
All right, Ms. Ferguson, can I have a 30-day reset on, is a 30-day reset enough time?
Yes, Your Honor.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Martinez? All right, so we'll be back on June 16th.
Thank you.
All right, you're excused. Thank you so much. Yes. All right, anybody who needs to approach, you need to have your file up here. We're gonna be taking our reset at
It's up.
12.
My file is up there,
Mine
Mr.
is.
Lawrence.
Brianna St. John.
Judge, she's an inmate. They took her downstairs because she became aggressive and spat at either the deputies or somebody else.
They were not able to bring her. She started arguing with other inmates and wanted to start a fight at the jail prior to being transferred this way.
Judge, probation wants to do a eval, the DDRF or MIA eval and a MIC.
So if the state withdrawing the motion to have those done?
They're not withdrawing the motion. I'm just asking to get it reset so they can do that while she's in custody. And your probation officer said the next eval time would be 6/6.
All right, Ms. Ferguson on Brianna St. John. Can we recall this in June, please?
Yeah.
All right, June 27th. I'll
Thank you,
just get a
Judge.
reset form from the coordinator.
Thank you, Judge.
Yes. All right, if you all will please take a seat, I have the files here. I'm going to call it. We're trying to keep it as uncongested as possible. All right, who's here on Porter? Shamarcus Porter?
Yes, Kevin Compton.
All right, we're calling this back for 1:30. She said she'll try to make it back. Angel Briceño?
Present, Judge.
Yes.
This is a pretrial diversion case. The contract's been filed. Now we're waiting for the acceptance of the application's been filed, waiting on the contract. Ask a 30-day reset.
All right.
June 25th.
All right, June 23rd.
Third.
All right, thank you.
Thank you, Judge.
You're welcome. Anna Ramirez? Yes. Where's Miss Ramirez?
She's present.
Yes. So what is happening with this case?
So we got an offer from the state. I do have a motion to amend bond conditions. The state has agreed to amend it to supervised contact with the child.
And is this supervised contact through CPS?
CPS and or the therapist. They're trying to do family therapy through Mary Contreras.
State?
Yes, and I've spoken to the CPS attorney who's handling the case on the CPS side, and in contemplation of the facts in this case, the state can agree that she's only allowed to have supervised contact with people.
All right, do you have all discovery?
Yes, I believe so.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Ramirez, please?
Come back on the 14th, June 14th.
And Judge, I'm sorry, I do have a vacation letter in from the 6th to the 17th of June.
All right.
So we can do the 27th.
All right.
27th, okay.
You're coming back on June 27th, get a reset form. That will be your plea deadline date.
Okay, thank you.
Stephen Rhodes. Stephen Rhodes. Back at 1:30. Hannah Smith. Yes. Yes.
We asked for an offer today. We still have not received an offer. I need to get an expert regarding the synergistic effect between marijuana and alcohol in the driving. Today we were recalled. I had a bond hearing last week that was denied. Mr. Rumer would not agree to a bond again today. Her family is here wanting me to ask again for a bond. So that's where I'm at.
All right. If you want to present on evidence for that, then we'll have to come back at 1:30.
I'm not going to be presenting any additional evidence than what I've already presented.
All right, thank you. So that'll be denied. Ms. Ferguson, can I have a 30-day reset for Ms. Smith? Will that give you enough time to file whatever motion?
Yes, Your Honor.
I can do the 14th.
All right, we'll come back on June 14th.
Judge, and we, in the interim, we'll meet with the next of kin on this case and get a offer to Ms. Guerrero.
All right, I'll put down that the state is to make an offer on June 14th. Of course, if you make it before then that's great. Jean Carlo Armstrong.
Judge, maybe approach real quick on that.
Yes. Who's the defense attorney?
Teresa.
All right, yes. All right, could we go on mute, please? All right, on Mr. I'm sorry, John Carlo Armstrong, we're gonna come back on June 14th. Burton Stuhler,
President.
what is happening with this case?
Judge, we have rejected the offer from the state.
Judge, I was appointed in March in court. I'm hoping to get just a trial date, but for maybe July, so I can get some motions filed.
All right, Mr. Stuhler, come forward, please. And we're gonna take off right there, 12 and 5. Just go there. All right, and so today was the plea deadline date, Mr. Stuhler, so you're requesting a jury trial? All right, Ms. Ferguson, can I have a jury trial date on Burton Stuhler, please? All right, we'll see you back on June 27th. Make sure you get your reset form and make sure you're dressed appropriately for trial.
Thank you, Judge.
You're welcome. Jose Espinosa.
Yes, Your Honor, my client is not accepting the plea offer in the state's case.
Jose Espinosa. All right, my understanding is that an offer has been tendered and you're rejecting that offer. All right, what that means is the court will not consider any further offers. Do you understand?
Yes, Your Honor.
And we're gonna set you for jury trial. Just give me a moment when the
Yes, sir.
coordinator comes back.
Judge, I know the court is setting some cases on June 27th. I have a vacation letter, so. I think we're good.
All right, thank you. All right, I need a jury trial date on Mr. Espinoza and June 27th, Mr. Jimenez has a vacation letter. Is this criminal trial division? Mr.
I'm sorry, Your Honor.
Jimenez is Jose Espinoza, is that criminal trial division or family violence?
Criminal trial.
Okay. So we just need to get a jury trial date for that.
We'll do June 21st.
All right, June 21st. All right, and Ms. Ferguson will give you a reset form.
Yes, Your Honor.
James Lawrence,
Present with counsel, Judge.
what is happening with Mr. Lawrence?
You signed an order for discovery of the blood discs. The state announced 60 days to get it.
All right, and state, is that going to be 60 days? Do we know?
But as far as I know, I believe Marcus was the one who signed off on it, but I will get it over there and get it back as quickly as possible. If something changes in that regard, we'll let George in the court know.
All right, thank you. Ms. Ferguson, on James Lawrence, where's James Lawrence?
Right here, Judge.
You need to come forward. On James Lawrence, can I have a jury trial setting in 60 days, please?
Judge, I haven't even reviewed the disc yet.
They're saying they're gonna have it maybe before 60 days. Of course, if you have not reviewed the disc, then of course you can't go to trial. But I'm giving you your jury trial date.
I can do July 15th.
All right, July 18th is your jury trial date and plea deadline date, Mr. Lawrence. The coordinator will give you a reset.
Did you say the plea deadline date?
Yes, and jury trial date for July 18th.
Both of them at the same time.
Yes. So if you enter a plea on that date, then of course you won't be going to jury trial. If you decide not to accept the plea on that date, then you will be in jury trial. Kilpatrick Taylor. Kilpatrick Taylor. Yes, what is happening with this case?
Good morning, Your Honor. We're here for trial. Mr. Taylor's been patiently waiting for his day of trial. I've
Well-
noticed that there's a very important surveillance video.
Well, we
That's,
were here on April 14th.
yeah,
And on April 14th, you are to have viewed videos. So has that been done?
no, my best efforts, I've contacted the DA's office to get the production of that video. None has been produced.
All right, Ms. Ferguson, on Mr. Taylor, we're gonna come back at 1:30. So we'll see you back at 1:30. Mr. Taylor, we'll have you back at 1:30 to make sure that, no, I'm gonna make sure I go over whatever you have, okay? We're gonna do it at 1:30.
Appreciate you. Lauren.
All
Thank
right,
you.
you're welcome.
Mr. Taylor.
Bernard, are you okay to do this last, please? All right, who are the parties on Derek Sherrard?
Judge, Monica Goodell's in the hallway, that's plea, but I will cover the plea for her. It's now.
All right, thank you. The court is calling 2022 CR 2483, State of Texas versus Derek Sherrard. Can I have parties announced for the record for the state?
Bree Sparks from the state.
And are you Mr. Sherrard?
Yes, ma'am.
And standing in for Ms. Guerrero?
Joseph Stateson and Mr. Sherrod, would you give the judge permission for me to do the plea in place of Monica?
Yes.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sherrod, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? It appears that you are.
I believe that we're repeating a repeater offender allegation, Your Honor, and just for purposes of the record, this is Michael Villarreal from the state.
All right, any objection to the waiver of the repeat offender allegation?
No objection.
Mr. Sherrod, I'm showing you what's entitled waiver and consent to stipulation. Sorry, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated robbery? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years of life in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
We believe he was, and we believe he is competent, Your Honor.
Mr. Sherrod, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything to get, other than the plea bargaining agreement, to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargaining page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine and no applications. Did you understand that to be the plea bargaining agreement?
Yes, ma'am.
Defense, is that the plea bargaining agreement?
It is, Your Honor.
State, is that the plea bargaining agreement?
Yes, Your Honor.
Mr. Sherrod, do you understand if I find that there's a weapon involved, that then this will be an affirmative finding of deadly weapon? Did you understand?
Yes, ma'am.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motion?
No, Your Honor.
Then to the offense is charged, how you plead, guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state of states exhibit number 1 and its attachments.
Any objections?
None.
Mr. Sherrod, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence statements, exhibits 1 and attachments, and review the same. All right, after reviewing the state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Court will follow your agreement. The court will sentence you to 6 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money run concurrent, and there's an affirmative finding of deadly weapon. Is there anything else with regards to sentencing?
Nothing further from the state, Your Honor.
Nothing from defense.
All right, Mr. Sherrod, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Good luck to you, Mr. Sherrard. Mr. Sherrard, know better, do better.
Thank you, ma'am.
All right, good luck.
Thank you, Judge.
You're welcome. All right, everyone, we're gonna take our recess. We'll be back at 1:30 p.m.
Thank you, Judge.
You're welcome.